Continuing production of The Open Mind has been made possible by grants from the Rosalind P. Walter Foundation, the Bluestein Family Foundation, the Thomas and Theresa Mullarkey Foundation, the Garfinkle-Minard Foundation, the Center for Educational Outreach and Innovation at Teachers College, Columbia University, the Commonwealth Fund, and from the corporate community, Mutual of America. I'm Richard Heffner, your host on The Open Mind, and my guest today is a leading constitutional lawyer who has appeared on this program so many times I really feel he shares it with me. Floyd Abrams is a partner in the prestigious law firm of Cahill, Gordon, and Reindel. He is known far and wide for his devotion to free speech, First Amendment causes. Well, the last time Mr. Abrams was here, it was for a program titled Loosening Lawyers' Lips, which, incidentally, I began by going back a half dozen years and quoting from an earlier program we had done together, based on his New York Times Sunday magazine article on Why Lawyers Lie. Not do they lie, but why they lie. Well, I introduced my friend then as internationally known and admired for the cases he tries and the appeals he argues for clients high and low. But right now I know some people who aren't that admiring. Why? Because at the moment, Mr. Abrams has joined Kenneth Starr of Bill Clinton, Monica Lewinsky impeachment fame in taking the recent finally passed McCain-Feingold campaign finance bill to court, the Supreme Court of the United States, in the hope that it will be overturned there as a violation of the First Amendment. Money talks is the thought, and it must enjoy free speech. I don't, of course, know precisely who Ken Starr's and Floyd Abrams' clients are, but one reads about the National Rifle Association, which for so long has made the gun lobby's political contributions pay off so well legislatively, and arch-conservative Republican Senator Mitch McConnell, who so ferociously and for so long led the battle against McCain-Feingold in the Senate, even threatening to filibuster it to death. Still, when the New York Times Sunday magazine recently noted that he has joined forces with some famous right-wingers and asked whether he has therefore taken a lot of heat, my guest said, some, from people I don't know but who think, or thought, well of me. A letter complained that I was allowing myself to be used by the hard right. My view, my guest continued, is that the proper way to view this is not whether I'm being used, but whether I am correct. Of course, I would begin today by asking my friend Floyd Abrams not whether he's being used. I know perfectly well he's too darn smart for that. But whether he's simply as skillfully as he can representing still another client, clever enough to retain his legal services, representing that client just as single-mindedly and as purposefully in court and perhaps out of court too, as he has told us at this very table, lawyers always should represent their clients if America's adversarial legal system is to survive and thrive. Would that be a fair response, Floyd?
It wouldn't be, it's fair, but it's not complete. This is primarily a pro bono matter I'm doing. I mean, it happens I'm also representing the National Association of Broadcasters, and I will be paid something by them. But this is at its core, and in terms of the great bulk of the work that I'm doing pro bono, and it is a matter of belief. It's not because I was asked if I would do it. I was asked, but because I think it's very important that the people that my political friends think should lose win.
Not just your political friends. I am not your political friend, but
No.
I believe at hope too.
No, I know. But most of the people that I know are on the other side, and some of them are very, very troubled at my new associations. In a way, interestingly, that they would not be if I had represented on the same basis the virtual pornographer who won in the Supreme Court just a few weeks ago, or the Nazis. My friends wouldn't be coming to me then and saying, how can you associate with those people? But because it's, what, the right wing of our country, that it is presumptively a sellout or a betrayal, I don't think so. And I think it's a very sad thing. It's not a new thought, but it is a sad reality as I view it, that just about everybody cares most about the First Amendment when the views that that person wants expressed are imperiled, or the country as they view it is being changed in a way that they think unattractive. So the Republicans vote against the national funding for the arts. The Republicans vote for a constitutional amendment to ban flag burning. Not the senator I'm representing, actually, on that, because he voted against it. But just about all Republicans voted against it. And all Democrats voted for legislation, campaign finance, that I think on the face of it ought to lead good First Amendment caring people to say, are you kidding? You're going to have a law saying that at times close to an election, speech has to be restricted the most? You're going to have a law saying the National Rifle Association, as you say, and the American Civil Liberties Union, which is joined on our side of the case, and the AFL, which is joined on our side of the case, really can't do ads on television saying, as the AFL did in the 96 campaign, Senator so-and-so vote in favor of an increase in the minimum wage. That's now going to be a crime? Well,
Floyd,
it seems to me that people have lost their First Amendment bearings. What a lot of people have done, in my view, is to choose, unknowingly, but to choose campaign finance reform, which they favor, over the most standard, orthodox, obvious First Amendment sort of principles. That speech matters, that it matters especially around elections, that we especially protect it when it's about political matters, and that escapes people, and that it becomes a matter of condemnation and contempt on the part of a lot of institutions, including some great newspapers that I care about a lot. It seems to me to miss the point.
Do you think it would be possible to have campaign finance reform without endangering free speech, as you see? This endangers free speech.
Yeah. Well, I think that there are certain things that you could do. The question is it enough? You can certainly have much broader disclosure requirements, more immediate, more revealing.
Where did the money come from for this?
Right. With some exceptions. I mean, I still agree with my friends in the ACLU that they shouldn't have to reveal their membership lists or the people in the Libertarian Party who joined our case, which is basically a membership organization where people contribute money to the party and the party buys ads and whatever. There are some situations where I would be very sympathetic to the notion of non-disclosure, but the rule ought to be a disclosure. That's one thing you can do. Another thing you can do is to toughen up your criminal laws. That too wouldn't solve everything, but if what we're ultimately most afraid of is people really buying influence, we could have stricter sentences, we could have more prosecutions if people do bad things.
Is the buying, so-called, so obvious?
No.
So much on the surface?
No, and I mean, as a matter of fact, I don't really think it happens.
You don't think?
But there is a lot of people think it does, and I think it could assuage their concerns if we had a more serious, vigorous, focused, and even draconian body of law with respect to the punishment of political figures if one were to conclude that they really took money for votes. So that's another thing that you could do. And a third thing that you could do is to do some of the things that Congress did, but with a little more delicacy, a little more. Well, instead of having a total ban on all soft money, which means that unions will not be able to, unions which, to be fair now, are barred and have been for a long time from making any contributions or expenditures. But even when they speak about public issues, where they are allowed, as everyone's allowed, to speak out anytime, as much as they want, you know, one could have perhaps in some areas monetary limits, but we've gone so far now down the road towards a total ban on soft money, meaning what was unregulated funds, even if they're used for perfectly legitimate purposes. For example, party building, get out the vote drives, or issue ads. Now, there's a disagreement in this case about what an issue ad is, but putting aside what the definition is or should be, nobody would doubt that everybody has the right to take out ads if you've got money, advocating changes in policy, even if we can limit how much people effectively speak out about who to vote for. And you know, maybe you could play around the edges with numbers and the like. But what I see here is, in part out of frustration, maybe, mostly in good faith, but nonetheless with a total willingness to ignore the very significant First Amendment interests in allowing people and organizations and groups to have their say about public matters at the time it matters most, close to an election.
Floyd, do you think there was a real problem that the Congress attempted to address?
I think at least there was a real perception problem in certain areas, and in some cases a real problem. But as far as I'm concerned, most of the real problem could be dealt with by having monetary limits rather than flat bans. And in some areas, it seems to me, we simply have to make some hard choices. For example, I mentioned issue advertisements. Put aside the First Amendment. It's a serious policy issue. What shall we do about what would we like to do? What should we want to do with regard to advertisements that people put on close to campaigns which do deal with issues, but also, obviously, are pointed in the direction, sometimes very strongly so, of pushing one candidate rather than another? What shall we do about an ad of the National Rifle Association, say, which condemns President Clinton's positions about gun control not too long before an election? Now, my reaction to that, maybe is through the prism of my First Amendment work, but my reaction, which is the same as the U.S. Supreme Court so far at least, is to say if it's at all close, we'll bend in the direction of First Amendment rights. And we'll say to the NRA, just as we'll say to the ACLU, you can go ahead, and Congress can't limit you, even if it's close to an election, and even if you mention the name of a candidate for president. Now, what this new law does is to say, within 60 days of an election, if you mention the name of a candidate for federal office and the money is paid for by soft money, it's a criminal offense. And to me, that is so antithetical to First Amendment principles, one of which, to me, would be that whether it's a union or a corporation or a political party, and certainly if it's a group like the ACLU or the NRA, and it's important that they're together in this lawsuit, that when you go out talking about public issues, especially when you're close to an election, the government shouldn't be able to come in and tell you to shut up.
Floyd, with all due respect for those who disagree with you, how do you explain the fact that there are those who say Abrams has such strange bedfellows, et cetera, et cetera? How do you explain the phenomenon, as you describe it yourself, that those who traditionally are First Amendment oriented, in this instance, feel that you're wrong?
I think it's a few things. One is that it's impossible to disassociate this totally from the political circumstances out of which it arises. Republicans have tended to be in favor of having more, quote, rights, unquote, to spend money. Maybe
because they have the money.
Maybe because they think they have it. Democrats have been more on the other side. Now, I've been learning about campaign finance as I've been doing this case, and it's interesting for me to learn, that the Republicans do very well the more you increase the amount of what's called hard money people can contribute, as the statute does, from $1,000 to $2,000. The Democrats lose badly if people can't make large individual contributions. The Republicans lose if corporations can't. But I ask myself, what about these guys in Hollywood who were the subject of much publicity recently? A $7 million contribution by one person to the Democratic National Committee to build a headquarters. Page 1, New York Times. Page 1, Washington Post. I ask myself, am I tone deaf to this? I don't see the problem. I think he's doing a good thing. I think he is playing a role in the political process, helping the party that he thinks best represents him, and in his way, being part of a First Amendment governed process of speech. And so when people tell me, well, that's soft money. Maybe he'll get favors. Maybe. I mean, it's not ridiculous to worry about it, but it seems to me that if you know who it is and you know the amount of money the person's given, that people would be careful about doing things which could easily be seen as a favor. And I don't know where the parties are going to get the money to do a lot of things which most people would think are good things or okay things to do. Political conventions. Where's that money going to come from now? Most of the money for political conventions is, quote, soft, unquote, money. And as we go down the road of saying you're not allowed to give soft money, really just about at all, almost totally at all anymore, where are we moving on that front? Where we're moving is not that people or organizations or corporations won't be able to give money to those organizations, not to the political parties, but they'll be able to give them to use the pejorative term, special interest groups, or to use a nicer term, groups that care about certain issues. They'll be able to give it to the National Rifle Association. They'll be able to give it to other groups that care about right to life or choice for women. And those groups may thrive in their way, but they won't be able to spend it themselves. And I think that's a skewed way to approach this issue.
Let me ask you this question. How would you respond to the arguments you've just offered? What is the most telling response to what you've said?
Well, the strongest argument on the other side is the argument that basically says we're awash in money for elections. And people that have more money, entities that have more money, obviously get something from giving it. They wouldn't give it if they didn't think they would get. And they therefore imperil the system in terms of public trust and risk a level of corruption or something close to corruption by their power. Now, part of that to me, a part of that at least, is another way of saying, in President Kennedy's language, that life is unfair. Some entities have more money than others. If that's what you really cared about, if you cared about the unfairness in that sense, you might want to have a genuinely much more progressive tax system which addresses income disparity in the country, instead of going after speech. All this seems to me a shortcut when you go after speech. We could have public financing. Now, Congress doesn't want it. I'm not saying it's likely at all. But if you want to talk about how to address this in a way that does not threaten First Amendment interests, you could go the ACLU route. When they joined our lawsuit, they said they were in favor of public financing of elections, not limiting what people can spend, but assuring that there's a reasonable amount of money available to everybody who's running, a floor.
Most frequently, the floor goes along with a ceiling. Most frequently.
Sometimes.
Well,
it doesn't have to, though.
Doesn't have to, but if it did, you would take the same position.
Well, yeah. I mean, look, I'm blurring in a way because the statute does a lot of different things. I'm blurring a few different things the statute does. One is its limitation on these issue ads if they're close to an election and mention a candidate. Another is the total ban on soft money. A third is a total ban on any minor giving any money. I mean, would you believe it? Maybe it's not the biggest deal, but it says something about the state of mind of the Congress that passed this legislation, that we now have a situation where no one 17 or younger is allowed to give $1.
What do you mean by state of mind? What do you think that state of mind was?
What Congress, at its best, was afraid of is parents giving for children, right? But they didn't do that law. The law they did was children can't give. And that is reflective of the lack of care given to what I view as the speech elements which are at peril by this statute.
Do you think you could write a law that would bring some comfort to your present opponents? Some comfort to your former thinking?
I'm not sure, because I'm not sure if all the things I've talked about would be enough to satisfy them. Even if you had some more public financing, even if you had more disclosure, even if you had more enforcement, say, of criminal laws, I think Senator McCain and others would say that's not enough. That really doesn't address the problem. Now, in my work in the First Amendment area, I'm used to that. I mean, I'm used to saying to Congress, as I believe the Supreme Court did just a few weeks ago, you know, we really understand why you want to deal with this problem, but, you know, it's a free country, sweeping First Amendment protections, and we generally choose to run the risk of more speech, even if it's sort of uneven or unequal. When this issue first came to the Supreme Court in 1976 in the Buckley versus Vallejo case, there was a line written by Justice Brennan writing this opinion for the court in which he said that the idea of treating someone differently when the person tries to speak because of the amount of money the person has is alien to our First Amendment approach. And I think it should be alien. But there's no doubt that a more egalitarian approach would be to impose greater limits. I just think it's inconsistent with core First Amendment principles to start trusting the government, the Federal Election Commission, and the Congress to go draw lines and enforce lines about how much speech you're ultimately allowed.
In other words, you don't feel, to use words that we're familiar with, that there is enough of a clear and present danger posed by the huge amounts of money that go into American politics.
You have to finish the sentence.
To do this deed.
No, not to do this. Not to do this. To the extent one thinks this is, I mean, I have some of my new friends are of the view that we don't spend enough on elections. I'm not there yet, and I'm still thinking about that. Well, we'll see. I am a lawyer at the end of the day. I don't know where I'll wind up on that. I mean, we do spend more on yogurt than on elections, and I think about that. But even when I think, look, we've got a problem here, what can we do about it? My answers to questions like that are not, I've got it. We'll tell the ACLU they can't do ads close to elections. We'll tell the Christian Coalition they've got to shut up close to an election. That is just so much an attack on core First Amendment values that I can't buy it.
What would you think of the fact that I'm being told to shut up, that our time is over? Floyd Abrams, thanks for joining me today. And thanks, too, to you in the audience. I hope you join us again next time. If you would like a transcript of today's program, please send $4 in check or money order to the Open Mind, P.O. Box 7977, FDR Station, New York, New York, 10150. Meanwhile, as another old friend used to say, good night and good luck. Continuing production of The Open Mind has been made possible by grants from the Rosalind P. Walter Foundation, the Bluestein Family Foundation, the Thomas and Theresa Mullarkey Foundation, the Garfinkle-Minard Foundation, the Center for Educational Outreach and Innovation at Teachers College, Columbia University, the Commonwealth Fund, and from the corporate community, Mutual of America.